Protecting wine. How and under what conditions geographical indications can be registered? What does geographical indications mean? Geographical indications are a way to ascertain the name of the country, region, or locality from which a given quality, reputation, or other characteristic of the wine can be attributed to a specific region. All geographical indications are covered by Article 22 of the Trade-Related Aspects of Intellectual Property Rights. It is a powerful marketing tool for producers of wine to identify their goods as having a unique characteristic which is specific to that region. It is also the ability to use the reputation of the geographical indication as well as enabling consumers to benefit from the geographical indication as they can have an assurance that of the origin or character of the wine products purchased from that region. A well-known geographical indication within Australia is the Coonawarra region from South Australia, and one from overseas is Champagne from France. These wines have a reputation for flavours, depths, and other wine qualities such as the specific taste of vintages due to their geographic location. Australia has two ways in which geographical indications can be protected. Firstly, certification trademarks of geographical indications made under the Trademarks Act 1995 through the Australian Competition and Consumer Commission, and secondly, geographic indication protection made under the Australian Grape and Wine Authority Act 2013, which is made through the peak industry body Wine Australia. There is a potential third way, which is through the tort of passing off. However, you just need to prove the elements of the offence, and it is in relation to damages resulting from a misrepresentation of the wine product. Under the Trademarks Act, there is the ability to get a certification trademark. This is a sign used or intended to be used to distinguish a good or a service. Certification trademarks are an indication that the wine meets a certain standard in relation to quality, composition, or its geographical origin. Certification is overseen by IP Australia and regulated by the ACCC. A good example of this is the King Valley example, as shown on the screen. This was registered as a certification trademark in 1984, and it carried with it an endorsement that the mark will only be used on wine originating in the King Valley. King Valley is located in Victoria, and the association has now incorporated over 70 of the vineyards and wine producers who used the old mark prior to the name change in the association, and now all wine from the region uses the mark on the right. The process for applying for a certification trademark is similar to an ordinary trademark. However, it must follow specific rules as outlined in the Act as a minimum. Under the certification trademark system in Australia, it can also help with registration overseas. It also gives the proprietor an ability to give notice to object to importation and prevent people from using geographical indicators that are registered. A major disadvantage is that after registration of a certification trademark, it is available for everyone in the region to use, and therefore decreases the value and there is also potential damage to goodwill of the original proprietor. A register of protected geographical indications and other terms is run by the Australian Grape and Wine Authority under the Australian Grape and Wine Authority Act 2013. Winemakers, grape growers, and industry associations from anywhere in the world can apply to have their geographical indications registered and protected within Australia. Currently, there are 114 registered Australian geographical indicators. This includes in New South Wales, the Hunter, Mudgee, Orange, Canberra, and the Riverina areas. The Act was introduced to ensure that Australia is able to fulfil its obligations under wine trading agreements and other international agreements. The Act creates an offence through Section 40C, which pertains to the sale, export, or import of wine with a false description and presentation, and is punishable by 2 years imprisonment. Section 40D of the Act outlines what is considered to be false in the circumstances, meaning the description and presentation may be false even if it indicates a geographical indication from where the wine originated from. People who are entitled to make an application to have their geographical indications registered are those who are declared wine-making organizations, declared wine grape growers organizations, organizations representing winemakers, organizations representing growers of wine, winemakers, and growers of grapes. Regulation 25 of the Australian Grape and Wine Authority regulations sets out a number of different factors for determination of an application. These include things such as the history, development of the area, the existences of natural features, existences of constructed features, and already construed boundaries. The application fee is currently at $27,500, and the application will not be considered unless there have been trademark owners or other people invited to object to the proposed geographical indication.